Sir, section 20, agar aap, I read it out last time also, section 20 of the PICA law. Whoever intentionally and publicly exhibits or displays or transmits any information through any information system which he knows to be false and intimidates or harms the reputation or privacy of a natural person shall be punished with imprisonment for a term which may extend to 3 years or with fine which may extend to 1 million rupees or with both. Now, my lord, as your lordship had also mentioned on the last date, the Islamabad High Court had actually struck down section 20, the part of it that deals with injury to reputation. I have the, sir...
Is it reported judgment?
No, sir, I don't think it... But
is it in any of these paper books? Sure. ये पूरा judgment है?
No, sir. There are some other judgments which I'll be referring to. I thought this would be easier.
Which page?
Sir, the first page, sir. It was only a short order.
Can we read it?
Ji, sir. For reasons to be recorded later, petition...
Have the reasons come?
No, sir. I don't believe they have.
Achha. Okay.
For reasons to be recorded later, petitions are allowed, and it is declared and directed as follows. Freedom of information is a fundamental right, and it reinforces all other rights guaranteed under the Constitution. Free speech protected under Article 19 and the right to receive information under Article 19A of the Constitution are essential for development, progress, and prosperity of a society, and suppression thereof is unconstitutional and contrary to democratic values. C. The criminalization of defamation, protection of individual reputations through arrest and imprisonment, and the resultant chilling effect violates the letter of the Constitution, and the invalidity thereof is beyond reasonable doubt. The Prevention of Electronic Crimes Amendment Ordinance 2022 was promulgated in derogation of the Constitution and the fundamental rights guaranteed thereunder, particularly Articles 9, 14, 19, and 19A. The jurisdictional preconditions were also not in existence. The Prevention of Electronic Crimes Amendment Ordinance 2022 and promulgation thereof is declared unconstitutional, invalid beyond reasonable doubt, and it is therefore struck down. The offence under Section 20 of the Prevention...
The whole ordinance has gone?
Sir, वो एक amending ordinance आई थी, वो strike out, down हो गई. उसके बाद एक एक्ट आया है सर.
अच्छा, okay.
जी सर. And then F, which is relevant.
That is not relevant.
जी sir.
Okay.
F दो.
So the judgment has been implemented.
जी sir. And I don't believe that any, the learned Attorney General will correct me, but I don't believe any appeal against this judgment has been preferred.
No, but if the law has been amended, then...
नहीं sir. जो F अगर देखें, F वो original ही था.
Okay, let's read it.
जी. The offence under Section 20 of the Prevention of Electronic Crimes Act 2016 to the extent of the expression or harms the reputation, and the punishment thereof is unconstitutional, invalid beyond reasonable doubt, and is therefore struck down. Then proceedings against petitioners in connected petitions are consequently a nullity and are quashed, agreed complainants. Then, my lord, H, federal government is expected to review defamation laws and the defamation ordinance 2002 and thereafter propose appropriate legislation to Majlis-e-Shura for making its implementation effective.
I don't understand this. What does this mean?
My lord,
H. What does it mean?
My lord, as
what
far
precisely? I don't know what it means. It's very generalized.
Yes, sir.
अच्छा, चलें आगे पढ़ते हैं.
Sir. The Secretary, Ministry of Interior, Government of Pakistan shall probe into the conduct of officials of the cybercrime wing of FIA, which had led to widespread abuse of powers and the consequent grave violations of fundamental rights of the citizens. Court expects Secretary, Ministry of Interior will conclude the probe within 30 days from date of receiving a certified copy of this order.
For our purposes, you are, the only relevant bit is F.
Jesus.
The rest is not relevant for our purpose.
Yes, sir.
Take.
But although it does note that FIA has been abusing its powers generally, that is the second aspect. I'll come to that later. Now,
or harms the reputation.
Jesus.
So you want the words. Now let's read section 20 again.
Jesus. Whoever intentionally and publicly exhibits or displays or transmits any information through any information system which he knows to be false and intimidates or harms the reputation or privacy of a natural person shall be punished
so
with imprisonment.
You just want or harms the reputation deleted.
My Lord, and I would additionally urge that even the or privacy is too vague an expression to be permissible under the limited scope of the exceptions to Article 19. Your Lordship will appreciate.
Read Article 14.
Sorry?
Article 14.
Article, ji sir, dignity sir.
Privacy to wahan aata hai.
Ji sir. The dignity of man and subject to law, the privacy of home shall be inviolable. No person shall be subjected to torture. Now,
so why privacy you want to expose?
My Lord, my submission is that Article 19 ka scheme ye hai कि the restrictions that you impose on the freedom of speech, first of all you have to define them through a law.
No, but Article 14 gives privacy of home.
Bilkul sir. So the question over here would be, is this offense relatable only to privacy of home? Because what it is applied to is that this is our private, if a journalist is reporting on some public official's conduct, he says this is my private affair, you have breached my privacy, and therefore the FIA should pick you up. That is the problem, sir.
You can't just throw out privacy. You can qualify it.
Yes, sir. Bilkul.
How would you qualify it?
What happens is, sir.
No, what happens? Shone. Again, that's.
Case law.
The best law you can misuse.
Ji.
So that's. We're going to. How would you like to qualify privacy?
My Lord, the same way that if there is some particular kind of thing that they are looking to stop, that is,
can someone photograph you in your sitting room, washroom, or wherever? I would imagine you will say no.
Yes, sir.
So how would you attend to something like that then?
My Lord, that is the function of the legislature. The reason is
that's not defamation; it's privacy.
Ji, sir.
He's not, I'm just someone is taking pictures of you.
Yes, sir.
So there is no defamation here. Yes. It may be defamatory as well, but that's another aspect. But
yes.
Generally, it's not.
It may be.
It's just a privacy issue.
It may be a breach of privacy issue. Now,
if you take out privacy completely, then people will be leaning over the wall and taking pictures of you, and they find that they can't do anything.
Yes, I appreciate your Lordship's point. That has to be protected, and it is a permissible object under the exceptions to Article 19. What I'm saying is that if the law is vague, it can cover everything and nothing.
That's why I'm saying, can you suggest some qualifying words that we can then interpret Section 20 in that manner and restrict its scope? That's what we are asking you.
My lord, it would be, I mean, I could come up with some formulations right now, but there may be things I miss and it may be too broad or too narrow.
By all means, you can supplement them later. I'm not saying give an answer now and then, because when I put it to you that or harms the reputation, you're saying this is domain of defamation. If there's a thief, I call him a thief, I'm not defaming him. But of course, I'm harming his reputation. So, but then the burden will shift on you, and I can sue you for defamation or whoever the concerned person is. Point taken. When you, because the judgment of Justice Athar Manila does not talk about privacy.
No, it doesn't.
He left it out. You want to introduce something new now.
Yes.